Prosecutors and George Zimmerman's defense attorneys are returning for a second week of jury selection in Zimmerman's second-degree murder trial. Our coverage of the killing of Trayvon Martin, the trial of George Zimmerman, continues with Leila McDowell reporting on Florida's Stand Your Ground law.
Florida's Stand Your Ground law specifically states that a person has a right to use deadly force if he or she reasonably believes it's necessary to prevent great bodily harm to herself or himself. Critics call it a license to kill.
He had only been 17 for 3 weeks, and he was unarmed, and he was shot and killed by George Zimmerman, who claimed, based on the Stand Your Ground law, that he had done nothing wrong.
These laws incentivize vigilantism, take the law into your own hand, kill or be killed. That's beneath the civility of a great nation.
The Trayvon Martin killing put a spotlight on the legislation, igniting protests across the country and criticism from around the world, from average citizens to celebrities.
It's just that if we can't feel safe enough to have our kids leave home, go buy Skittles, go do whatever they do with their friends, 17-year-old, you expect them to come home.
The same year that Trayvon Martin was shot, Stand Your Ground was cited by the alleged killer of teenager Jordan Davis as a defense. 45-year-old Michael Dunn said he shot the teen because he felt threatened after they argued over whether Jordan and his friends should turn the music down in their car. The teens were unarmed, and Dunn was eventually charged with first-degree murder.
They pulled the sheet up to his neck because they didn't want me to see the gunshot wound. And then I went over and I hugged my son and I kissed my son. And I said goodbye to my son.
According to the Tampa Bay Times, 73% of those who killed a black person face no penalty at all, as compared to 59% of those who killed a white person. The Urban Institute found that in Stand Your Ground states, 34% of the homicides are deemed justifiable when the shooter is white and the victim is black. But when the shooter is black and the victim is white, only 3% are acquitted. The protests forced the American Legislative Exchange Council to suspend its lobbying for the law. The controversial and corporate-sponsored organization was pushing for Stand Your Ground in other states. Since the shooting of Trayvon Martin, Florida Governor Rick Scott agreed to form a panel to investigate the law.
We had a very diverse group of individuals from all across the state. They held hearings around the state, all public. They got a lot of input from individuals all around the state. So they put out their report.
The conclusion of the governor's report?
This is good public policy. We should stand beside law-abiding citizens. They should not be treated as a criminal. They're doing something positive, which is stopping a violent act from occurring. 27 states in the United States have identical Stand Your Ground laws. Leila McDowell, Arise News, Washington.
Criminal defense attorney and HLN legal analyst Joey Jackson is here with us with more on the case. We're always happy to see him. Also joining us via Skype is retired Florida Circuit Court Judge Phyliss Kotey. Thank you so much for being with us.
Thank you for having me.
I appreciate it. I want to come to you, Judge Kotey, and talk about the Stand Your Ground law. If you'll sit tight for just 1 second, let me just do a little bit of housekeeping on the procedure with Joey here. So they have 28 or 29 potential jurors that they've selected. They've got to get to what number?
About 40. What happens, though, Debbie, is that first they're doing sort of pretrial publicity clearance for the jurors because you want to get a jury who's receptive to your argument. So you have to speak to the jurors. Have you heard about it? If you've heard about it, do you have an opinion? If you have an opinion, would it prevent you from serving? So they do all that pre-clearance in the first round, right? And then for those who are qualified, meaning, yes, I've heard, but I don't have any opinions, because, of course, many people have heard about this. Everyone's heard about it.
Right.
So they're up to about 28, 29. Once they get a group of 40 who are pre-cleared, now they'll go into the second round, Debbie. And in that round, now they can start what I call trying their case. What do you feel about gun control? What are your views and your thoughts about self-defense? Does a person have a right to defend themselves? And so that's where they'll get. So they'll continue with that more today. And just briefly, Debbie, as a side note, of course, they still have to get to the issue of whether that 911 tape, whether there'll be experts who could opine about that. So they're stopping today at about 4, and the judge is going to hear more testimony from the defense as to whether or not, it's called a Fry hearing, right, to see whether scientifically acceptable methods for determining voices on that 911 tape, the judge is going to hear from a defense expert and then make a decision as to whether they could opine as to whose voice was on that tape yelling help.
Will we hear her decision decision by the end of the day, or will she deliberate for a while?
I'm presuming she'll reserve decision, think about what's what. It was a hearing, if you remember, a couple of weeks ago.
Yep.
They started the hearing. It had to be adjourned because the defense witness was unavailable. So I think she'll take some time and decide it. But that's an interesting dynamic going on. As you're picking a jury, she's making the legal decision as to whether or not to admit evidence.
Indeed. Let's talk about the second phase. So then they really get into what I call the nitty-gritty questioning.
Absolutely.
When they find this pool of 40. Now, do they have to choose their 6 and 4 alternates from this pool, or is there a chance they would scrap it and start all over again?
Well, they won't do that because it's been a lot of time. But here's what happens briefly. You have what are called peremptory challenges, right? There are these 10 challenges that each side has, and they could use. And what that means in English, you can strike a juror for any reason or no reason as long as it's not predicated upon discrimination. Like what? Like excusing an African-American juror primarily because of race, gender discrimination. However, there are challenges for cause. So say if in this round of questioning, Debbie, a question is asked, well, did my client have a right to defend himself? Would you agree that people do? Well, no, I don't really think so. I don't know that would be appropriate. You may have a strike for cause. So depending upon, and those are unlimited, right? You could strike all day and night for cause. But I think with this pre-clear jury, they have a sense that these people could be fair and reasonable and decent. So I think as a result of that, I'm assuming we'll get a jury by the end of the week. I may be optimistic, but
yeah, I think that is optimistic. Gosh, we sure hope so, because it's been a long process. All right, thank you for being so patient with me, Judge Kotey. Thank you. I appreciate it. Let's talk about the stand your ground law that is prevalent, is in existence in Florida and several other states around the country. How should this law actually work?
Well, I mean, it should work that when law-abiding citizens are in a place where they have a right to be, they should have no duty to retreat. And further, that they should be able to defend themselves. So that was the whole basis of the law and the law in any other country, many other states, in terms of why it was enacted, to give law-abiding citizens a right to kind of stand their ground and not have to go anywhere when they're being attacked.
Via Skype with us, joining us is a retired Florida judge, Phyliss Kotey. Phyliss, I want to come back to you. I thank you so much for your patience. I apologize for the breaking news. That's what happens in this business.
Absolutely.
Let's go back and talk about the stand your ground. You were explaining how it should work, but it seems that at least the spirit of the law, as it is interpreted around the country, has created a lot of ill will. It's caused regular folk to sort of have a decrease in faith in the justice system, as well as one critic says now wonders if gutting the prosecutorial discretion in many self-defense cases has created a legal no man's land. Is this concept flawed from its core?
I think you're correct in saying the spirit of the law itself becomes the nature of the flaw, because anyone can say, I felt reasonably threatened, and if they're in a place where they legally had a right to be, whether that was a teenager that just happened to be in their neighborhood or happened to be knocking at their door, and in their own minds they created this fear, the law seems to give them protection. And that's the problem with it, the subjective nature of anyone being able to say, I felt fear.
And doesn't it sort of change the way law enforcement behaves, too, where the law exists?
Oh, absolutely. I remember reading accounts of gang members being able to say, well, they threatened me. And I was just protecting myself in terms of when I shot them. And other people who may or may not be people that necessarily would be entitled to that kind of protection because they were creating some sort of controversy, being able to assert the right because the victim's dead. The person's dead that can refute them.
Indeed. Joey, I want to bring you into this conversation. I see you nod your head, so I know you want to say something, but also there's a bit of an irony here, because if we remember back last year, the whole reason that George Zimmerman was not arrested for 44 days was because of this stand your ground. Yet the defense is not using it in this case.
Interestingly, I think it was a strategic decision, because here's what happens. The stand your ground law, Debbie, gives you an immunity from prosecution. You have a hearing, and if at that hearing a judge concludes by a preponderance of the evidence, that is, it's more likely than not that you stood your ground, didn't have a duty to retreat, you were in imminent fear for your life, you're immune. But I think in this case, it's so political, Debbie. Why? Remember, the prosecutor didn't go to a grand jury in this case. They decided, Angela Corey, unilaterally with her team, to charge second-degree murder. I think the thinking of the defense here was, look, even if we have a hearing, it's not likely that the judge is going to dismiss the case, right? Because I think the community would be outraged. It's more likely you leave it to a jury. So I think the defense didn't want to have that proceeding, have their client again on record giving statements as to what they needed to do that they could be impeached with at trial. Because the more a defendant speaks, the more likely there will be an inconsistency, and the more likely the prosecution, if you're worth anything, and this prosecutor apparently is very good, is going to use that against them to say, you said one thing one day and said another day. Which one is it? And I think for strategic reasons they didn't do it, but I think they will make a motion during the trial, Debbie, to say, look, we have established this was self-defense under the guise of stand your grounds, and we're looking for a dismissal.
Very interesting. We'll talk about it.
Right.
We're going to have to leave it right there. Judge Phyliss Kotey, thank you so much for your patience. Thank you for your insight. We do appreciate it. Perhaps we'll speak with you again sometime during the course of the trial. And Joey Jackson, as always, thank you.
Pleasure, Debbie.
We'll see you again soon.
Hope so. Thank you.